As we're wrapping up 2023, per tradition, I always um, talk about or list my top IP highlights for each year, and this is the fifth edition. And if you're already following me on any of my social media platforms, I'm pretty sure you may have seen my list for 2023. But the good thing is, this is the podcast version for those who would like to listen to me talk about the cases. I'm not going to go in depth because I have a lot of cases for this year. There are a lot of trends, a lot of development cases, and still more cases up until the last day of 2023. So stay tuned for my top highlights.
IP, IP,
IP,
IP,
IP,
IP,
IP,
IP, IP. Welcome to IP series, home to all things IP related, where I give you the stories, tips, and implications to business and creative decision concerning your intangible assets with real life case study. I am your host, Rita Anwari-Chinda. Subscribe and turn on your notification so you don't miss an episode. Cheers, guys.
At the center of the IP conversation for 2023 was artificial intelligence, generative artificial intelligence work. But first, at the beginning of this year, we had a couple of works go into the public domain, such as we have works like The Best Thing in Life Are Free by George Gard De Silva, Lil Brown, and Ray Henderson. Then we also have To the Lighthouse by Virginia Woolf. I think that's the pronunciation. Then you have Time Regained by Marcel Proust, the jazz singer, um, and a couple of others. And we're also gearing up for the biggest IP work owned by Disney going into the public domain in 2024. And I'm talking about Mickey Mouse. There've been so much publication about that. I think sometime this year, Mischief also created like a limited line in like a merchandise of some sort in preparation for Mickey Mouse going into the public domain. And we all know, like just like their name is Mischief, they are very mischievous. Now, the first on my list for this year, you know, I added it to my list for this year after I had posted the initial top highlights, and I first got the link from a mentor when he sent me the link, but I had already seen it on Twitter. But yeah, he also sent it to me, and I said, okay, since this seems very important, so I'm going to add it to my list when I'm doing the podcast. So, number one. So for number one on my list, and I think a lot of my AP friends will agree, is the recent copyright disputes between the New York Times and OpenAI, makers of the Chat GPT. Now, summary for this is New York Times is claiming that OpenAI has trained on millions of their articles and write-up, their content, without their consent, permission, and authorization. Basically, using their intellectual property to generate answers and content for users. And if you are very active on social media, you see a lot of content creators highlighting and sharing tips and prompts on how to use ChatGPT and other artificial intelligent tools to create content, to write ebooks, to create images. I think that's one I saw yesterday, where a user had put in a prompt that they should create like a cartoon like image, which the result at the end of the day was a combination of Mario and Lugu. I think that's how it's pronounced. But these are some of the questions or issues that this dispute is basically highlighting. What does it mean for the future of artificial intelligence, creativity, journalism, publishing, content creation, you name it? How will it affect the balance between innovation, creativity, and IP protection in the digital era? Now that you have, I mean, with the digital era, is you're dealing with issues of ease of reproduction. Now you have chat GPT with just basic prompts coming out with outputs. There are questions as to whether these prompts enjoy intellectual property protection. um would these suits redefine the boundaries of artificial intelligence and intellectual property? Would the fair use defense work in favor of open AI and Microsoft? So at fair dealing basically, or fair use, depending on the jurisdiction you're coming from, basically you using an intellectual property work without the um need, without you wanting to commercialize or make profit from it. So it could be for private use, to criticize, to create parodies, for research purpose, as long as you acknowledge the original author and you're not making money from it, then you're good to go. Under our new Copyright Act, Section 20 lists four factors that will be considered um, to determine whether the use of your work or the defense of fair dealing, how or fair use would work in your favor. Looking at also the copyright requirements, in order for a work to be eligible for protection, um, which is originality, being in a fixed or tangible format, irrespective of the quality. Then um, it also turns out that parties, or I think it was the New York Times that had reached out to OpenAI, um, makers of the Chat GPT, sometime in April to try and negotiate. And I just thought about it. I mean, I have been thinking about writing it, but this case kind of just stretched or motivated me to, conclude that write up as to whether ADR mechanisms such as negotiations um, would be best in resolving AI related disputes or generative AI related disputes. Um, so parties were unable to reach an agreement, hence why this process was filed. One of the terms that I read was that um, the dispute was basically focusing on the terms of the licensing agreement with other news organization, payment of royalties, and OpenAI um, claiming, or OpenAI being charged for or asked to pay damages for the unauthorized use of the New York Times publication. So this is like a summary in less than 5 minutes. Remember, I said I have a lot more cases. So let's delve into highlight number two. So highlight number two, which I did not include in my initial carousel and what do you call Twitter or former X post now? I don't even know. XXs, whatever. Is the choreography case between Kyle Hanagami against Fortnite for using his how long dance routines, beats, and sequence of moving in the Fortnite Chapter 2, Season 3, in August of 2020. So during the pandemic, basically, I mean, given that Fortnite had like a good year, I think, no, I think, yeah, Travis Scott had used Fortnite for his virtual concert and made a lot of money from that. But you will not find out that pre the pandemic, Fortnite already had cases that were filed against it for unauthorized use of choreography. So basically, this case of Hanagami and Fortnite highlights the protection that choreography enjoys as an eligible copyright work. And this, like I said, this will not be the first rodeo that fortnights would be having. If you were or are a fan of what's that famous Will Smith movie? Hold on. Yeah, finally figured it out. The Fresh Prince of Bel Air, which also had like a reboot of some sorts. And the actor Alfonso Ribeiro in 2018 had sued Fortnite for using his um, dance routine in one of their series known as the Backpack Kid. And they also have rapper 2 Milli who alleges that Fortnite Epic stole his viral dance move, the Milli Rock, selling it for V-Bucks as Swipe It. Um, all of these suits were filed after they had applied to copyright their dances, but they were all dropped in 2019 following a US Supreme Court ruling that owners can't sue until Copyright Office has taken on an application for copyright. So in jurisdiction like the US, it's kind of like mandatory. You're mandated to register your work. Failure to do that means you can't sue. You know, but the lights at the end of the tunnel for choreography work was the what's his name now? Let's see. Jackie Knight's case. You know, he basically set the precedent in terms of obtaining copyright protection for his distinctive choreography. Um, he's the first choreographer to actually receive a copyright protection for his choreography, and because he understood the importance and the power that doing that will aid his brand and giving total control and creative output, he founded the Night Choreography and Music Publishing Inc., which enabled him to have greater authority and ownership of his choreography. He's the one that curated the single, all my single ladies. Yeah, if you are a dancer, you know how I won't say difficult, but the single ladies dance routine is out of this world. If you're looking to burn a few fat, that's a good song and dance routine you can consider adding to your playlist. He also paved the way for other choreographers to gain recognition and protection for their choreographic creation. Then there was the what's that now? There was a black um Twitter campaign against TikTok, still the pandemic era and I think a year post pandemic era, where black TikTokers went on strike because TikTok did not acknowledge the original creators of certain dance routines and moves that were viral and were being racial about it. I wrote about it in my blog, so just type in IP series Substack and then you will see the publication there. But then, in conclusion, when you're talking about choreography, it also goes to show that the growing body of choreography copyright infringement cases will keep coming up, and people like Hanagami, who know the importance of protecting their choreography, will keep suing. Now, what I put down in my note was, if this was in Nigeria, would the Federal High Court rule in favor of Hanagami? Yes, because the new Copyright Act makes provisions or protects choreography works. And if you also check out the interpretation section of the new Copyright Act, it's still new, I mean, basically less than a year. The Nigerian Copyright Act defines choreographic words to mean a composition of movement for dancing or other pattern succession of gestures mostly created to accompany music. So if you are a Nigerian dancer, if you help artists or theaters come up with dance routines, just know that you are protected under the law. Your work is considered to be a literary work. If you also look at the definition of literary works, choreography works is also listed, and section, give me a minute, yeah, section 9 gives you the rights, exclusive right to reproduce that dance routine, to publish it, to perform it in the public, to produce, reproduce, perform, or publish any translation of that dance routine or choreography work, make any audio visual work or a record in respect of the work, distribute it to the public for commercial purpose, broadcast it, communicate it, make the work available to the public by wire. Huh, maybe no. By wire or wireless means in such a way that the members of the public are able to access it from any place and at any time, make an adaptation of your dance routine. So, so another type of right you can categorize a choreography is um, choreographers and dancers enjoy performance rights. And under Section 63, it lists that you have the exclusive right to control the fixation of your on fixed performance, reproduction of your fixation in a performance, um, in any manner or form if the original fixation other than the fixation is excluded from section 68, which talks about exceptions to performance rights as a whole lot. So I think the exceptions to performance rights will include demonstration in good faith of a radio or television receiver or recording or playback equipment by clients, by a dealer in those receivers, reproduction of short extracts from an object of a performance right, research or private study of an object of performance right kept in publicly accessible libraries, educational establishments, museums, or archives on the premises of the said institution. And reading this now just highlights the Makola Queen's the musical performance, which I just did a review about. So if the school were going to rely on the exceptions, I think this will apply. Then there's also reproduction for benefit of people with disability. The new copyright act now has special provision for people with disability, which is a good thing. What else? Performers now also enjoy moral rights. So people like Hanagami, if they were Nigerians, have the right to be identified as a performer in connection with any use of that performance of the fixation in Fortnite Epic. They can also object and prevent any distortion, mutilation, or modification of the dance routines, the sequence, the beats, um, timeline for uh, protection. So performance includes dramatic performance, which includes dance and mime. All of you that did all those, if you mind when you were younger, you get what I mean. I was also going to consider dance as an expression of folklore, but I wouldn't want to delve. Okay, yeah. So folk dances and folk plays under section 74, sub 5, you know. Then yeah, I think that covers it. So let's move on to case number 3. So I for number 3, I think I came across this case the day I was, trying to walk around my slides or the carousel. And if you so there's this guy that always asks people how much money is in your bank account. And I think that was the first. I think it was the participant stories goes to show how people were intentional in trying to be financially independent. Some, and it was also exciting to. It was also inspiring. Not exciting. It was inspiring. I think one story that really caught my attention was the lady that said she makes $1 billion every Christmas. Kind of like Mariah Carey. Who knows that every so every Christmas it's time for her to make money. So you're just sitting and waiting for Christmas to make $1 billion. And they're like your when you see them on the road, they're kind of like your regular or everyday people who you just walk past. And so his name is Mr. Louis Liu, and he was calling out his fellow content creator on Instagram. He wrote, so I want to read it verbatim for verbatim what he wrote. So he says, it's okay to be inspired by someone, but copying something exactly the same is pitiful. So when I was writing this, I had to paraphrase it to be, it's all right to be inspired by others, but copying their work word for word is shameful. I don't even know which one is much better. Is it my own my own quote or his? But anyways, this case just shows the thin line between when one is inspired by a work and when one goes ahead to plagiarize it, and also looking at it, doing a comparison on whether or not that would fall under an IP infringement. It's also important to remember that as content creator or digital content creators, um, we should learn and grow in our craft. Um, Understand that it is very unethical for a creator to not appreciate the value of their inspirer's work and owning and also realizing the basic requirement, which is originality of the work. It is very important that while we are creating content and being inspired, we should always celebrate and support each other. um And like I stated in the post, I stated that when I was, when I came across this case, the case that came to mind in terms of storytelling was the Human of Bombay and People of India case, which I also did a podcast and a carousel and Twitter post about. So, how much is in your bank account is a very interesting IP highlight for me because I had to go to the other guy's page. His name is Jawan Ford, and his handle is at Ford Jawan. So watch the two videos. I think the difference, I think someone made a comment about the difference between Mr. Louis Liu and Jawan was that Mr. Lewis was always in luxury clothing, while Joanne was just in a regular high street or maybe a silent luxury clothing. I mean, that's what is trending now, isn't it? Silent luxury, not having those big logos all over you and trying to be very classy. But yeah, if you're a content creator and you're inspired by someone, always acknowledge the person and say, "Oh, I was inspired by this," or you get into a collaboration or a partnership with the person instead of copying word for word. Not good. Not good. Let's do better in 2024. Okay. So case number 4. I don't know why I never took my time to do a proper review, but I just thought I'll save it for the highlights. I mean, it's not everything that I have to write about. Sometimes I just read to learn and be abreast of what is happening in the community. So I got a DM from my friend David Perry. I like to call him Perry, not David, anyways. But Perry sent me a DM about this Starbucks case. And I was like, "She are going to do a review about it." So like, of course. But I just kept pushing and pushing, and here we are talking about how to protect your trade secrets and intellectual property in the restaurant industry. What are the best practices that you should go home with? So first off, um, this case highlights the economic value and the independent economic value that trade secret gives to a business, and how you may lose your reputation to employee theft, disclosure of confidential information, misappropriation if the employee decides to be very funny. So turns out that Starbucks terminated an employee's contract in October because they had leaked and shared recipes, ingredients, steps, and measurement for five of their popular drinks, which is the chocolate mocha, the coconut oil mocha, the macchiato, caramel macchiato, the coconut milk vanilla latte, and iced coffee latte. Um, they shared that information on the social media platform, formerly Twitter. Hmm. Now, Starbucks recipe was a closely guarded secret, just like the KFC chicken recipe, the Coca-Cola recipe, and several other recipe. I think again, this also what also came to mind was the Hidabasi Cookathon. I did an extensive review about IP rights in the food industry and for food bloggers and vloggers and tourists. What's it called? What do you call them? But there's like a term for that industry. Is it gastro something? Can't remember. I think that's something that the Koreans, South Koreans specifically, are exploring in terms of you know trying to get not just engagement but get people to understand the story behind some of their cuisines. So imagine your employees, and I think some businesses in Nigeria experience this where an employee comes in there without any knowledge and then they leave and start reproducing a similar brand. I think a colleague had mentioned this case, the Bobo Juice and Viju Milk case. But then, we've had a couple of other instances where businesses have been um, prone to such um, IP theft. There's a difference between IP theft, technical know-how, trade secret appropriation, and all of those conversations. So that's the fourth highlight for this year. If you're going into 2024 as a business person, it's very important that you have certain documentation present so that you protect your intellectual property from being stolen. I know jurisdiction some states in the United States, in US, are clamoring that the non-circumvention clause be removed and taken out of because they feel it stifles creativity and innovation. But if you're in a jurisdiction like mine, I would say as an employer, you should take measures to protect your intellectual property, be it a copyright, trademark, patent, industrial design, trade secrets, you name it. Whatever it is, include the right clauses, the non-disclosure clauses, the non-circumvention clauses, IP clause. Make sure that it's specific and not ambiguous at the end of the day. So as an aside, I watched the behind the scenes of creating the Gucci Bloom perfume, and that made me appreciate creativity more, invention more. I've also seen the behind the scenes of BTS or of what's it called now? Yeah, the Dior saddle bag, very lovely. So BTS always helps me understand and appreciate the value that creators and inventors bring into this space, which is why counterfeiting is a bad thing. You know, I think Nigerians were having a blast when they were talking about and showing counterfeited products in the markets, questions as to um, packaging issues, trademark, passing off, trade dress issues, and a whole lot just came to mind. The reality is, fake products are really killing Nigerians. Not just it's not a Nigerian thing, but counterfeiting is considered to be a form of intellectual property infringement that involves the production, importation, sale, or distribution of goods or services that are identical or substantially similar to those of the legitimate right owners without the authorization. I follow a lot of the UK anti-counterfeiting content online, and I think also the US as well. Everyone is fighting counterfeiting because it has serious consequences for not just the IP owners but also we who are the consumers, especially this Christmas period. I think it was the EU IPO that put out like a disclaimer of some sort of what you need to look out for. And I have also attended some sort of webinar that talked about things to look out for in terms of determining whether this product you're buying to give to another person for Christmas is genuine or not. Website link taking you to the wrong website and you end up ordering the wrong product, or your distributors not even being aware that they're actually getting um bad products. For the IP owners, it can lead to loss of revenue, damage to their brand reputation, and also make their employees to lose their job. So I think it was one of these luxury brands that had to, so they found out, I think, in one of these Asian countries that an employee was creating a counterfeited version of the luxury brand and selling it as the original brand for top money, like the money no be here, you know. So how do you then control some of these things? I think some brands have incorporated using blockchain to determine for transparency and also track um, the products when they leave the store to when they get to their final destination. They also put in serial code numbers that they use to identify whether the products are genuine. Kudos to Lake Dora, Mrs. Dora, Professor Dora Nkem Akunyili OFR, who was the Director General of the National Agency for Food and Drug Administration and Control of Nigeria from 2001 to 2008. I mean, she made a huge impact within the Nigerian space when it comes to fighting of counterfeited products and trying to ensure these are, again, I'm going to try to make this short by listing the penalties um and the type and extent of infringement. So some possible penalties for counterfeiters will include imprisonment, fines, forfeiture and seizure of products, injunction, damages. You know, you also need to also consider that using fake products can cause serious health issues such as eye infections, allergic reaction, nervous system toxicity, organ system toxicity, um, loss of sight, hearing aid, miscarriages, infertility, high blood pressure, which are caused by exposure to harmful ingredients in counterfeit products, um, diarrhea, kidney failure, anemia. Like, how do you people sleep at night when you do? How do those counterfeiters, not you people, not my happy friends, basically, but how do counterfeiters actually sleep well at night, knowing that they are causing so much harm? So, what would now be the role of the FCCP, which is a federal competition and Consumer Protection Commission, NAFDAC, and the Standard Organization of Nigeria? What are the roles of this agency? They're basically responsible for regulating the power sector, food, drug, cosmetic, clothing, automotive parts, um, and some of the measures that they've taken in combating fake products include simplifying the process of laying complaints. And I'll give kudos to the FCCPC. What I ordered against what I got, and many for online. imposing stricter penalties, collaborating with other stakeholders such as the Nigeria Customs Service, the National Drug Law Enforcement Agency, the Pharmaceutical Society of Nigeria, and the media to raise awareness and report cases of IP crimes. Can you sue a counterfeiter for damages in Nigeria? Sure, yes, you can. Um, Damages is basically at the discretion of the court. At the end of the day, what else? I think elements of counterfeiting in Nigeria involves making, copying, or imitating of any trademark. So I have this. So it's the trade malpractice miscellaneous offenses act. You have the counterfeit and fake drug and wholesome processed food miscellaneous provisions act. So it's a very short law with just 13 section. Penalties, provision of sale of drugs or poison in certain premises or places. Any person who hawks or sells or display for the purpose aids or abets, including a market, kiosk, motor park, etc., etc., shall be punishable under the law. Now, reference to appropriate authority will mean reference to any person or body authorized to grant licenses or register premises for the sale and distribution of drugs or poison. Penalties 500,000 or imprisonment for a term of not less than 5 years or more than 15 years. A liable under section 2 sub 1, the person may be liable to a conviction to a fine not exceeding 500,000 or imprisonment for a term of not less than 2 years or both such fine and imprisonment. Trial of offences. The Federal High Court has the exclusive jurisdiction to try such offences. There's also the establishment of the Federal Task Force, function of the Federal Task Force, establishments of police, Nigeria Police Fraud Squad. Then section 10 talks about forfeiture of drugs or unwholesome processed food products. I think there was one time where they were dumping expired chicken, and people were complaining that instead of doing that, you should give it to people that can't afford to buy those things by themselves. And I'm like, that is unhealthy. It's not good for you to eat. Then the trade malpractice offenses would include any person who labels, packages, sell, offers for sale, or advertise any product in any manner that is false or misleading. So let's look at a couple of those examples that I had shared in that post. So you have the Amore um soy sauce, sesame, oyster sauce. You have Evra, you have the sniper. So instead of sniper, you have sniper. Instead of close up, you have open up. Instead of Henneken, you have Henneken. Instead of Bama, you have some other thing there. And then there was this video that went viral on social media where there was a bust in one of these production illegal production not companies but illegal places. They were creating um filling up drinks in wine bottles. It was, I mean, I don't know. I really don't know. Then there was another one again I saw about two Chinese men um putting something inside a Milo package, and they were like, "Oh, these people are in Nigeria." I'm like, how do people really sleep at night? You know? So there's also the provision for the establishment of malpractices investigation panels to include the Ministry of Commerce, Internal Affairs, Health, Petroleum Resources, Solid Mineral Development. There's also the mining issues as well. Ministry of Industry, Science and Technology, Finance, Central Bank of Nigeria, and the Standard Organization of Nigeria. All of these organizations, we need to really put our hands all hands need to be on deck. This cannot keep happening in our dear country. What this is going to show is that we have the potential to actually create those. But counterfeiting is ruining all of this. It's taking a toll on everyone. Purchasing counterfeit goods supports illegal and often unethical practices such as child labor and organized crimes. True. I think there was one time Primark was accused of that. Just, I think you see that a lot within the fashion industry where there's a lot of conversation as to sustainability, um, child labor per se. I think one time someone posted that if you really want to know if your clothing was created by, oh, apologies, guys, created through child labor, check, just turn your dress inside out and you see that somebody wrote something. I think I had one of these and I was like panicking of some sort, but I was like, ugh. So, in conclusion, it's important for individuals and, and businesses to be aware of the risk associated with counterfeiting and to take steps to protect their intellectual property. I mean, it's one thing to register, it's another thing to monitor. So that's a lot of investment. I think in the episode where I had a senior colleague come talk to us about, so there was this Adire scenario where the Chinese were importing low quality Adira and people were not having it, conversations like that. So check out that episode as well. That was also very detailed. I think it's more than an hour, but it's worth your listen. So please, please support your girl by listening to that episode. Uh, we can also start implementing anti-counterfeiting measures such as holograms or serial number. I think we're already doing that, but these people are smart. I think they're always a step ahead of the government or the agency or the IP owners. And I know that under the new Copyright Act, there's a provision for um, where the commission is going to be working with the customs in terms of what's it now? I'm trying to look for it though. Restriction on importation, which is section 55, where the DG will request the commission to notify Nigerian Customs Service during the period specified in the notice to treat as prohibited goods any work in respect of which right has been infringed upon. So all hands needs to be on deck for this one. So I don't want to spend too much time talking about this because I think I'm already doing that. But preventing counterfeiting is a collective responsibility that requires cooperation between government, right holders, and consumers. So, for highlight number 6, I'm going to be talking about the Oja Piano case. So, I've been following this case for a while now, and sometime in November, specifically 27th of November, the O2 Connect had published that KC and E-Money 5 Star Musical gifted Ibonile Ojazi a Lexus car for his birthday and was said to have signed him to 5 Star Music. This was also shared by Ambassador of News on TikTok. So the backstory was so my colleague Moses Malan had shared the link with me about how Igwe Credo stated that um, Casey did not pay them for their contribution to the Ojapiano music. Said how one junior pope had reached out to him to be featured in Casey's hit song Ojapiano. I remember a few years ago, Casey was accused of IP theft and infringement from um, another for another hit song, which is a cultural praise from a priest. I know Chukun also had reached out to me to get my views, but sometimes some of these cases I try to stay away from it. It doesn't be like I be toko toko. I'm not a gossip blog. But then I followed the story and also did my a bit of research in terms of what are the copyright implications for all of these in terms of how does this impact the um the music industry, what should artists and producers know, um is this going to be like a new genre or another controversy within the music industry, and what is the musical impact to all of these, and how can the Nigerian music industry help artists overcome some of these challenges and achieve their full potential by not just protecting and enforcing the IP right, but also being knowledgeable about the business of music. How can they be fairly compensated and recognized for their contribution? to a musical work, and all of this boils down to lack of awareness. I think a lot of creatives or artists get carried away when a celebrity or an A-list artist reaches out to them, which is why we're currently seeing a lot of social media call outs from artists, and people not keeping to terms, not drafting proper agreements. Um, I wouldn't say lack of regulation and enforcement. We have a new copyright act, and there are provisions for technical protection measures that artists can explore. There is also the takedown proceeding, which wasn't there before. There's also restriction on importation, anti-piracy measures. Um, what else again? And several other provisions are the new act. There's also the dispute resolution um, board, which ends the Nigerian Copyright Commission will create to resolve disputes on licensing, payment of royalties, and any other thing they deem fit to be determined by the commission. Um, what else again? Then there is awareness and education, how musicians and artists can protect their work, creating and maintaining databases of registered and verified intellectual property rights, the roles of the collective management organizations, and people like P-Man. So listen to the episode with Mr. Mike Apan. There's also, I think I've talked about that again. I've talked about that again. So going forward, in terms of we need to motivate and reward Nigerian artists and producers, protect and enforce their intellectual property rights, sign the necessary agreement, don't do oral. Always make sure that you properly document all your conversations, the terms of the contract, agreement, how you can commercialize, how you deal with distributors, how to deal with record labels, um, platforms, consumers, people like also listen to your song, um, improving the quality and popularity of the music. So I had to Google the flute that was used to by Ojazi. I think that's his name. Yeah, that was used by Ojazi, and also what else? Artists needs to understand the business of music publishing, music licensing, how record labels comes in. Do you really need a record label at this point in your career? Um, um, how music licensing officers can also help emerging artists and musicians, creating a vibrant music ecosystem, cultural heritage, preserving our cultural heritage, and encouraging artists to explore their cultural roots, um, picking your niche and building on that. Other challenges would be piracy, lack of structure. What else again? I think that basically covers the conversation. But if you have a different view regarding the Ojapiano dispute that is still growing, please send me a DM or email to ipseries info@gmail.com. Always willing to listen to another person's opinion though. So highlight number 7 is going to be very short, and that's me talking about the passing of the Nigerian Copyright Act 2022. I did like an not an I did a 2 hours plus review about the new Copyright Act. So if you haven't listened to it, please do. And I also started like a Nigerian copyright review post highlighting certain sections I felt creatives should take note of. I think it's about 9 or 10. I'm going to continue next year. So this new act has about 100 and let's see, hold on. I need to be sure 109 sections. So the part one of it talks about the objective and application. So the objective of the law basically is to protect the rights of authors to ensure just rewards and recognition for their intellectual property. So linking it back to the Ojapiano case, your the law takes care of this when it talks about protecting your rights and not ensuring that you're rewarded and recognized for your IP efforts, for your intellectual effort. Then provide appropriate limitation and exception exceptions to guarantee access to creative work, which is where the special provisions comes in. So you have general exceptions, then act for purpose of instruction or examinations, recording of broadcast by educational establishments, restriction on reprographic copying by educational institution, subsequent dealing with authorized copies, special provision for archives, libraries, museum and gallery, special exceptions for blind, visually impaired and otherwise print disabled people, and finally special exceptions in respect of sound recording of musical works. And I think that would apply. Let's see. It's 27. Musical. Anyways, let me not delve into that because I said I already talked extensively about that. Then the third objective is facilitate Nigerians' compliance with obligations arising from relevant international copyright treaties and conventions like the Marrakesh, the Berne Conventions, the what's that one now? WPPT, yeah, and several others. Then enhance the capacity of the Nigerian Copyright Commission for effective regulation, administration, and enforcement of the provisions of the Act. So if you're within the creative sector, you have eligible works that fall or are listed under Section 2 of the Copyright Act, such as the literary work, musical work, artistic works, audiovisual works, sound recording, broadcast, and performance. Um, the Nigerian Copyright Commission is your regulatory body. Go and engage them, talk to them, align yourself with a collective management organization. Also talk to P-Man as well. P-Man should do a better job in terms of standing up for the creatives, But yeah, I think also Mobat's death also raised some very pertinent issues within the creative sector. In conclusion and in summary, go and learn about the business of your sector, whichever of the eligible works you have. Go and learn the business side of it, so that 2024 will have less of social media call outs and video takes and long Twitter posts. Not seeing one that can beat Kanye West yet, but number 8 is the debate about identifying artificial intelligence as an author within different jurisdictions. First, we have the judgment from the Chinese court acknowledging an artificial intelligence generated work or image that was created using stable diffusion. The courts, in its judgment, stated that that image called Spring Breeze Brings Tenderness, that was posted on the Chinese platform Little Red Bull, enjoys and is eligible for copyright protection. And so the author, Mr. Lee, who had sued Miss Liu for copyright infringement, um, was awarded some damages and with cost attached. I like when a court or a lawyer in filing an IP dispute includes cost for litigation. Lovely. Though the money was small, but then the precedent had been set in China that AI generated images or works are eligible for copyright protection within that territory. The case raised several issues, such as one, even though Mr. Lee had used stable diffusion, he took extra measures to include a copyright notice when he watermarked his image. Kind of reminds me of the Kelechi Iheanacho's case where someone put a watermark, Puja Media put his watermark and Kelechi removed it, and reposted it. They also have that issue of paparazzis and photographers suing celebrities for reposting images of themselves. Several celebrities are falling victim to this. So when I saw this, the first thing that came to my mind was the um the technological protection measures as provided for under the new Copyright Acts from Section 50. So it says no person shall manufacture, import, sell, or offer for sale, provide, or otherwise traffic in any technology product, service, device, or parts. Yeah. So if someone takes the extra measure to circumvent your the protection, the watermark or a notice you've put in by bypassing or removing, deactivating it, they have infringed on your work. Now, the law under subsection 3 defines technology protection measures to mean a technology, device, product, or component incorporated into the work which is designed to effectively prevent or inhibit the infringement of any copyright or related right. you know then second question is, can prompts used in an AI software or tools enjoy IP protection? I think I mentioned that when I was talking about the New York Times case in passing. Despite using AI tools, is Mr. Lee entitled to the exclusive rights and also enjoys such as economic rights, moral rights, and the exclusive rights? Based on this new judgment, I will say yes. If this was in Nigeria, would the technological protection measures apply? I think by definition, yes, this will apply. While copyright as an IP protects the originality involved in the level of human involvement, what would the threshold for AI generated work be to determine originality? That's another angle I think we need to pay attention to. Second AI case would be the US Copyright Office refusing to register its fourth AI generated work that was created with the use of an AI tool. The work in question is a two-dimensional computer generated image titled Suryast. I think it's Soyast, created by Ankit Sami, in part using a custom developed software program called Raghav. You can check out my post when I discussed the Zara of the Dawn case this year. I think I posted it in March. So there's a podcast version. There's like a short carousel slash newsletter version. The third case on my radar is the recent UK Supreme Court decision on Dabu's AI invention that only human inventors can be acknowledged under Section 13, Sub 2, Paragraph A of the UK Patent Act. And these are set some precedents and guidelines for regulating intellectual property rights, which focus on the relevant provisions of the law. Now, three issues that the court considered when it came to conclusion for the UK matter was the scope and meaning of the term invention. Was Dr. Taylor the owner of the said invention in any technical advancement made by Dabus and entitled to apply and obtain patent for it? And finally, was the hearing office entitled to hold that the application would be taken to be withdrawn? Yeah. So that's it for what highlight number is this now? I don't know. Highlight number 9 is the Jack Daniels um dog toy case. So this case basically highlighted the ways that business owners who might want to follow the VIP's lead can avoid being accused of trademark infringement, dilution, and other offenses. So, in order to do that, it's very important that you conduct a proper search, if possible, before you launch a new product or brand. Carry out like an IP audit or due diligence to identify any potential conflict with existing trademarks and allow yourself to make any necessary changes before launching. You also need to understand the different types of trademark infringements, which includes dilution and of course when a trademark becomes less distinctive due to overuse of other factors. In Nigeria, trademarks are protected under the Trademark Act and the Nigerian Constitution. The Trademark Registry is responsible for registering and enforcing trademarks, and businesses operating in Nigeria should ensure that they comply with the relevant laws and regulations to avoid any legal issues. But I think this case was kind of interesting because under the US competition, there were arguments as to whether this was free speech and all of those conversations that took place. So I did a carousel and also did a podcast version of this. So please check it out and let me know if you have a contrary view to my opinion. Highlight number 10 is the adaptation of the Alu 4 story into a movie titled Dark October. It was really a dark October in Rivers State, Nigeria, when these four Uniport University of Port Harcourt students were burned alive early hours of the morning after they were accused of stealing and all that. Now, when it comes to movies based on real life events, it's very important to understand that there's a legal concept known as right to oppose. Publicity also means that a person's name, image, voice, and likeness are protected by law even after that. But then this would depend on your jurisdiction. So if a movie is made that includes a deceased person's name, likeness, the family may have a legal claim against the producers of the film. May. I think there's this serial killers movie. What's it called? Is it Down? I think so. And Ted Bundy, all of those things. I know sometimes family object because they feel they are diseased. One, they want the dead, let the dead rest and be buried. Let bygone be bygone and all that. But sometimes some families, for some reasons, do not appreciate being reminded of the past. Some also feel that the adaptation may be exaggerated, while some may be after it for monetary compensation. Like you should have reached out to us, gotten our consent, etc., etc. Um, if a movie is based on a newsworthy event that showcases or highlights a particular issue in the society, I think um, the family in question may not have a claim. Additionally, if the deceased person, you know, I was going to say something about, let me just say that. But the best course of action for the family of a deceased person in this situation is to consult a legal professional who specializes in intellectual property, film law, entertainment law. They can guide the family whether they have a legal claim, what steps that can be taken to protect their rights of the departed one if they actually have a right. So I know Linda Ikeji got a lot of backlash from family, but jungle justice is something that we still struggle with in Nigeria. There was Deborah's case was an exception because it was in the north and there was conversation on blasphemy rather. Um, and with the recent killings in Plateau and the Middle Belt, my mom is Middle Belt, my mom is from Benue State, so it's a bit dicey. I know how I would feel if we get bad news from my mom's family that something bad happened. They were killed by, you know, it said farmer headers or something, or um, you know, it's complex. But the conversation I've been bringing for the last 3 days now on X platforms with people highlighting how some extremists have been killing people in the name of religion, um, or in the name of not in the name now, but trying to, like, a genocide is currently ongoing, trying to rid the indigenes of their birthrights and taking over in a very hostile way. You also see instances where people were burned for stealing. I think we had one this year when a female lawyer, was um attacked, false alarm, and then she was attacked, and she had some medical complications, those kind of things. So I think this movie um did its best to highlight that jungle justice is not a something that we should take for granted. But I think the family were not happy with the fact that the departed ones or the deceased family members were like the focus of the story. But then, you know please check out my conversation about that. I did an extensive review about that case too. Then we have the Domitila trademark saga, which was interesting to follow and getting to see um how it developed. So turns out that sometime this year, the Domitila Ashby work was to premiere, and then we saw that the lead actress and Choma and Jamanze was suing Zebe Jiro, the producer director. Um, Zebe Jiro Production and the movie sponsors Film One Entertainment and Film Tribe Media for trademark infringement. So she had just applied to trademark the name Domitila and was now suing them and trying to prevent them from launching. We all know that trademark infringement is a very serious offense that occurs when the person or entity using the trademark that is identical or similar to another party's trademark. This movie, which is a cinematograph work under the new art, it's no longer called. No, it's now called audiovisual work. Oh, Ejo, Mabini. It's now called audiovisual. No, yes, now audiovisual work. It's no longer cinematograph work as was stated in the former ad. They enjoy protection, and that means that filmmakers can register their work and protect it from unauthorized use by others. And there's also passing of protection for when a mark has not been registered. So you enjoy a limited form of protection under the law. At the end of the day, the her registration was opposed, and the trademark tribunal um, stated that she had registered the trademark in bad faith. Overall, this case raises important issues relating to intellectual property law and the protection of creative work. So check out my post about that and let me know if you watched the movie. I know I did a giveaway of some sort, but the person that won, couldn't. I don't know. Person that won, I couldn't meet up, and I offered to do some other thing, but he wasn't responsive. So if you're listening to this, I sincerely apologize, but I still owe you. So reach out to me and let me know what is within my budget that I can actually do for you, you know. So another interesting case was the case between Mr. Adewale Ojo against Airtel Network Limited, which sheds light on protection of image rights, especially when it comes to public figures, celebrities, or well-known people. Apparently, Airtel was ordered to pay the filmmaker, actor, and show business personality 20 million naira for the unauthorized use of his image and photo after their initial mobile no portable service agreement or contract that had elapsed in December of 2014 or 20 no April, yeah, that had elapsed in this that had elapsed basically, and also for the use of that image within that timeline. So he also shed light on the importance for businesses to respect terms of contract. So we had the case of Onyeka Owen, who had a music licensing agreement with iRockin TV expired, and they kept using it afterwards, even though the compensation was small. But then that set a precedent. Then we also have the Vironi case with Mercy Johnson recently. You know, I talked about that as well. So, do we have a specific law on image right? No, but I think with the right strategy, your lawyer and your team can come up with a good argument for unauthorized use of your image, especially when you're dealing with or talking about privacy related issues and stuff like that. Then there's Tom Browning, who won the four stripe motif case against Adidas three stripe case. The court held that the four stripe motif was not infringing Adidas. And I think I was watching one South Korean series, and I saw one of the actors wearing the Tom Brown. I was like, oh my god, look at this. You know, so I also talked about that I did a carousel, and also I think I did a podcast episode. Trying to remember, not sure, but that is another highlight for me for this year, especially because Adidas is very aggressive when it comes to protecting their three stripe logo mark. Like, Oga, calm down. Wait till this sup. You know, so if you're in the fashion space, please check out that episode. Figure out what you can do to stand out so that when cases like this comes to your table, your litigation team or your legal team or legal department knows the strategy to put forward the arguments in May, because in an event of a dispute, basically you have to cross check and carry out a due diligence to ensure that the IP was really, really infringed upon. So that is another highlight for this year for me. So my friend's husband has sent me this Bad Bunny case where, let's see now. So Bad Bunny was accused of copyright infringement and unauthorized use by his ex-girlfriend. And it was really interesting to see. And I was like, babe, this sue man. I mean, especially now where you're seeing artists try to what's the word now? Artists try to incorporate their kids into the music sector. So there's a recent song by Northwest guy. The song is banging. Hey, go and listen to it. But anyways, so that was like the first case I saw about Bad Bunny. Then I think Mr. Easy also accused him for copyright infringement as well. So I'm trying to get that story before I delve into the main thing that brought me here. Yeah, Bad Bunny faces $40 million lawsuit by his ex-girlfriend. This was posted by Complex sometime in March. So the girlfriend is the suit is based on her contribution to Party and Those Mills 16, where she memorably says, Bad Bunny baby, hey. But the second case, which I want us to, take note of is Bad Bunny, Karol G, Daddy Yankee. If you like reggae, you go know all these people are they call Pitbull, my man. So there's a reggaeton copyright lawsuit against several artists that I've listed, which is basically talking about a 1989 reggae track filed by Staley and Cleve. I think it's Clevy in 2021, and they are claiming that nearly 2,000 songs have sampled and interpolated the Fish Market reggae um, track. Most recent is that all of the defendants, including Bad Bunny, wants the lawsuit to be thrown out. And one interesting thing though is there a statute of limitation for when a trademark owner can actually register their eligible work. So this track in dispute is a 1989 track. So 1989 till today is 34 years later. That's like more, no, almost half of the term of protection that a musical work, sound recording enjoys under the law in Nigeria. And I think also in the US. I think it's also 70 years plus after the death of but I'm still following this conversation. There's question as to whether, can a code be protected? Can this is too many complex things. I'm like, these entertainment people, you people, too many things. You just have to keep reading and being updated. But this is the Bad Bunny case that featured in my 2023 IP highlights. So the next highlight never made it to either the carousel or the Twitter or X post I made. But it's basically talking about CAF signing a 3-year broadcasting deal with New World TV to cover 13 competitions, including the 2023 and 2025 AFCON Games, and a free to air and pay TV deal. Now, according to publication, New World TV is considered to be a new kid in the broadcasting business. And we already know the importance of broadcasting rights in the sports industry for sporting events. So I think I've mentioned or I've discussed this in one of my episodes when the Nigerian broadcasting um, company or agency had stated that um, companies, DSTV was mandated and compelled to sub-license their broadcasting rights to smaller TV stations in Nigeria. And then, I got tagged on that post and I did an extensive discussion and analysis of that um, directive or memo that went out. So if you really also want to learn more about broadcasting rights in the sporting industry and what the commercial value is and how important it is. I think you need to also take note of the Nigerian sports policy document and also read articles published by my friend Beverly Abakoba and several other authors out there. Number 16, oh baby shark do 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 dun, dun, dun. The song that has over a billion views on YouTube is now a registered trademark in the US under Class 9, which is for downloadable music files authenticated by NFTs. Now, this registration was concluded last month, November 2023. We all know the benefit of having a registered trademark, right? I believe if you have been following IP series, I'm sure you know. But I'll just dash you one. Exclusive rights. You get the exclusive right to commercially and consistently use that mark in the class that you register. Remember, you have 45 classes to pick out of. And it's only when you get your certificate that you can come and say, I have a registered trade. Oh my me, I have a registered trademark. You can also prevent other people from um, using similar names or trying to cause confusion in the market or trying to deceive people and stuffs like that. So if you are considering registering baby shark in class 9 in the United States, please die it. You know, dead the matter. You know that trademark and IP is territorial in nature. So in the US, yes, but there's also the conversation as to well-known mark. I think Baby Shark is well known for it to have a billion views and counting. Odura easy now. Check it. So another shocking highlight for me was seeing that Chocolate City may lose up to 60% of its equity due to a loan dispute under an ADA distribution agreement with WEA International, a subsidiary of New York-based Warner Music Group. Chocolate City is one of the independent music label in Nigeria and have been a major player in the Nigerian music industry. So seeing this news broke a lot of persons heart, myself included. And I think, not I think, on one platform, someone was like, "What were they thinking? They have lawyers on the board," and I was like, "Dude, calm down. We haven't seen the terms of agreement, so you guys should take a chill pill, you know." Um, and one thing again that stood out for me when I was reviewing this case, which is currently before the High Court of Justice in England and Wales Commercial Court, is that one, not a lot of persons know what an ADA distribution agreement is. I'm going to shed light on that. This is an agreement between the supplier and distributor of music products or services, and the supplier is usually an independent record label or artisan. The distributor is a company that provides marketing, promotion, and distribution service to the supplier. The agreement will specify the terms and conditions of the relationship, such as the scope of the product and services, the payments and royalty arrangement, the rights and obligations of each parties, and dispute resolution mechanism. Very important, you know. It said, I think according to publication, it said that the um loan is about 500,000, but if I'm wrong, please correct me. See, as I lower my voice as I dey talk that one, ba. Now, according to some publication, it said ADA Worldwide is a division of Warner Music Group, a global music distribution and service partner for independent artists and labels. Um, it's so when I was also talking about this case with, how will I describe Abam? Abraham is becoming my mentor. I say mentor, my it's more than a mentee right now because he's becoming a lawyer. Yeah, that's what I wanted to say because he just finished law school, and I've also featured in on my podcast. We talked about the Wakana case. So please listen to that episode with Abba Miracle. But then we delved into conversation on convertible terms, loan facilities, which are like a type of financing that allows the lender to convert their standing loan amount into equity or any other form of payment. They are usually used by companies that need capital but do not want to dilute their ownership or give up control of their business. He also provides like a flexible uh, um, arrangement for both the borrower and the lender, depending on the terms and conditions. So, how does equity conversion work? Debt equity conversion is a process in which a borrower company exchanges some or all of its debt for equity shares in the company. And this basically means that the lender becomes a shareholder or a part of the company, and the borrower reduces or eliminates its debt obligation. Several benefits for both parties. For the borrower, it can help improve its cash flow, reduce interest expenses, and avoid bankruptcy. Oh, I need to drink water. And restructure its balance sheet. For the lender, it can help to recover some or all of the loan value, gain a stake in the company's future profits, and avoid the risk of default or litigation. However, debt equity conversation can also have some drawbacks. And some common methods of debt equity conversation is conversation of bonds into share, conversations of loan into share. This is when the lender of a loan to the borrower company agrees to cancel the loan in exchange for a certain percentage of the equity in the company. In this instance, 60%. That's a lot. Then you have conversion of trade payables into shares. Now, how does intellectual property affect debt equity conversion? We already know that IP protects intangible intellectual output. Now, depending on the type and value of the IP assets involved, whether it's copyright, trademark, patents, industrial design, trade secret, the nature and terms of the debt contract, and the goals and strategies of the borrower and the lender, could have some effects, such as it can increase the attractiveness of debt equity conversion for the borrower, especially if the borrower has a strong and valuable IP portfolio that can generate future revenues and profit. It can also increase the attractiveness of debt equity conversion for the lender, especially if the lender believes in the potential and viability of the borrower's IP portfolio. It can also it can also create some challenges and risks for both the borrower and the lender in debt equity conversion. For the borrower, it can result in dilution of ownership, loss of control, and increased reporting and governance requirements. The borrower may also face some difficulties in valuing his IP assets, protecting its rights, and maintaining its competitive advantage in the market. And for the lender, IP can result in lower returns, higher risk, and longer time horizon. They may also face challenges in assessing the quality and validity of the borrower's IP assets, enforcing his IP rights, and managing IP portfolio. So I think just should I stop there? What are some of the ways to finance a record label? You can consider crowdfunding. Read the Nigerian Startup How to guide you on crowdfunding. You can opt for grants, sponsorship, equity. Um, I'm trying not to make this. Okay, so how does ADA agreement affect? I think I've mentioned that too. Why do I feel like I'm repeating myself? But how can a record label scale up successfully? One of the most promising and innovative ways is by using IP and debt equity conversion. Um, it can help record label improve their cash flow. It can also help them beat competition and reach new markets, secure their growth and profitability. Blah, 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 blah. What is? So yeah, I think lastly would be, what are the legal remedies for breach or default in a convertible term loan facility? One is termination of the loan agreement, enforcement of the security, conversion of the loan into equity, damages and injunctive relief, you know, um, difference between a breach and a default in a loan agreement may depend on the terms and conditions of the agreement, the nature and extent of the breach of defaults, and the applicable law and jurisdiction. So yeah, that's it for this highlight. So remember at the introduction or beginning part of my recording, I said that this year's IP conversation is centered on artificial intelligence. Now I have another AI dispute, which is the authors copyright lawsuits against OpenAI again, Microsoft again. So the authors will be George R. Martins, John Grisham, and other tech companies over alleged misuse of their work to train AI system. I think this is going to be like one of the major arguments for most AI disputes. So just like the New York Times dispute, I'm also following these disputes. I'm also trying to, not trying to. I also want to build capacity on artificial intelligence because it seems like that's like going to be what we build our 2024. So get ready, guys. So I'm sure we're used to hearing Mariah Carey has been sued for All I Want for Christmas. It's another copyright lawsuit. But this time it's Tupac's Dear Mama that was named in a new copyright suit. 30 years after it has hit the charts, there's a copyright related claim stating, this person infringed, it was my work, blah blah blah. But that's still building. So that's another highlight for this year, which was interesting to see. So next again is the Hamilton against Lewis Hamilton mark in the EU for failure to show it is a known and recognized mark, as the Board of Appeal stated that the special protection accorded to famous persons when applying for trademark did not apply in this case, relying on the absence of data for people from Bulgaria, Estonia, Croatia, Latvia, and Lithuania. I think we all know who Lewis Hamilton is. He had registered Lewis Hamilton in 2015, I think, in several classes. But as usual, when you register a mark and you don't consistently use it, you lose the right to own that mark, and someone can apply that your mark be cancelled or revoked. And this was the case in this dispute. So check it out, do more research on this. I think I've talked about revocation of a trademark, cancellation of a trademark, criteria, and what the law will look out for in several episodes. So yeah. So remember during the pandemic when it went viral that Pitbull had trademarked his famous Grito Hill. Now in 2023, just like Pitbull, Duracell battery was successful in his appeal to the trademark appeal board, as it overturns the decision of the US Patent Trademark Office that um their three notes slam tone, which they consider to be advertising, not enough to support their specimen in connection with the sale of the goods. The TTAB stated that the three note slam can be registered because the audio message transmitted repeatedly in section of the stores where the goods are located helped prove one of the requirements of trademark, which is used in connection with the sale of goods and services. So if you're going to do a trademark in any jurisdiction, please make sure that you engage a law firm or a trademark attorney or lawyer within that jurisdiction to tell you what their own law provides. Under our own law, you must show that the mark in question, which will be the the three note slam tone, is capable of distinguishing and is distinctive, is not similar, is not deceptive, and it's not the name of a chemical. You get. But sound mark is one of the most difficult types of trademarks that can be registered. You must really prove that there is a distinctive element to your mark that you want to register. And consumers play a huge role in helping you win that. But yeah, that's it. Number 22 is the Yuga Labs against Reeves, who is a non-fungible token artist, Ryder Reeves and Jeremy Karen, who a United States District Court ordered to pay Board AP Art Club creator Yuga Labs a total of 1.57 million in damages along with legal fees. Now, the summary of the findings of the court based on a post by someone I follow on LinkedIn, trying to remember the person's name, but she stated in her post that one, the basis for the remedies were that the defendant intentionally and willfully infringed Yuga's trademark through the creation and sale of a copycat collection of NFTs and the registration of domain names similar to Yuga's trademark. The court rejected the defendant's claim of protection under the First Amendment, fair use or parody, as well as claims of trademark abandonment or transfer. Then the defendants were found to have acted in bad faith with contempt towards the court and Yuga Labs, causing irreparable harm to Yuga's reputation and goodwill. So this case is kind of interesting because I think I also saw another publication on Twitter that highlighted that some of um the ape um NFTs were being stole. Yeah, got it. So it says a massive theft appears to be happening right now. All these NFTs have been stolen from wallets, some of the absolute top tiers apes. Conspiracy theory, not the not going to delve into it, but yeah. So the next highlight is the South African case of the Turkish trademark in dispute, when application for cancellation of the mark was made for being too similar and that it was like there was a likelihood to cause confusion. So the case is Grimbo Bimbo S.A.B DEC against Turkey's Bill Tony Pty in bracket limited. So check it out, figure out what's obtainable in South Africa, the relevant treaties when it comes to trademark registrations and all that. Now, in this case, it's pink all over. Can you guess? Can you guess? Can you guess? Can you guess? Please tell me you can. So basically, the marketing and branding team behind the Barbie movie, they deserve recognition because anywhere you see pink now you're thinking, is this a Barbie collection? I think I came no, I came across that audio on Reels and I used it for one of my posts. Is that the Barbie collection? Everything was pink themed. But basically, highlighting how Mattel has safeguarded Barbie through intellectual property, what film, advertisers, and toy industry can derive and learn from Mattel. And in today's world where IP theft is rampant, it is crucial for brands to take proactive steps in protecting their brands. The Barbie brand is a great example of how a brand can stay relevant and popular for over how many years. The marketing and branding team behind Barbie movie understood the importance of highlighting the steps taken by Mattel to protect the brand's intellectual property. By doing so, they not only showcase the brand's history, but also educated the audience about the importance of protecting intellectual property. I mean, Pink trademarking the color, Barbie trademarking the name, creating merchandise, doing an adaptation, blown. So if you've seen Barbie, I think for most movie critics, Barbie was in their top 20 movies for 2023. And one of the valuable lessons for those in the film, advertising, and tour industries that should take notes by taking steps to protect their brand, they can ensure their longevity and relevance in the market for years to come. I think Barbie or Mattel is also considering creating like a Barbie themed what's it called now? A Barbie themed park, which is good. More money for everybody. So kudos again to the marketing team and also highlighting that not everything pink is Barbie, but very you now understand the trademark element where you say you can link a product or a brand or use pink now as a source of indication when you're talking about Barbie. Or I think Barbie had a lot of collaborations with other fashion brands, creating a Barbie themed line, limited edition. They sure made money, lots of money, and I think the movie is currently worth $1 billion in the market. So kudos to everybody, Sha. Another controversial case this year was Twitter rebranding to X. What is X? The name no sweet for mouth. You get? But that's what happens when a brand is bought over. Do you retain the former name or do you create a new name? What the benefits of retaining the former name? Reputation, goodwill, a source identifier for brand. I think a lot of people like myself keep referring to Twitter as Twitter and not X because we're so used to the name Twitter. There's also like a trademark guide for rebranding for what brands can learn about that. Then Elon Musk now going ahead to accuse his former employers of X or Twitter, formerly Twitter, for breaching threads, for trade secret breach by Threads. Threads is another app that came out linked to Instagram, kind of like giving X or Twitter's vibe, but it's not as bubbly as Twitter, you know. So conversations rose up as to, oh, is this a trade secret appropriation, or was it like an espionage? Was it like a disclosure from the other parties? So what are the reasonable steps that brands can do to protect their trade secrets? You know, it also reminded me of the Tesla case during the pandemic where they're talking about self-driving cars, and Elon Musk again was also in the mix of trade secrets. So I think so many things that brand can learn while you're going into a merger or you're buying a property or selling your IP. Agree on terms, ensure that your employees don't carry away confidential information that could hurt your brand. But yeah, that's it. So this one went viral in Nigeria, and that is the Gangs of Lagos at movie, where the portrayal of the Eyo masquerade in the movie sparked a lot of controversies and debates. While some argue that it was simply a movie and artistic expressions, other people stated that it was disrespectful to their culture and tradition of the people of Isale Oko. And as an intellectual property practitioner, I believe that the producers of the film should have exercised more caution and sensitivity towards the portrayal of the cultural icon of the Eyo masquerade. Also important that filmmakers and artists and creatives understand the significance of cultural and intellectual property and how it can impact the communities it represents. Um, what else again? And yeah, work towards representing cultural tradition and practices in a way that celebrates and honors it. I think I have a no, I think I did a publication about it and maybe a podcast, can't remember right now. Now the Manuka honey dispute is another one that's caught my fancy. And hold on, I'm trying to get to it. But it highlighted um what's other intellectual property rights such as plant variety and geographication um, has in store for farmers and business owners who set certification standards for their trade association, and the trademark aspect to applying to a mark depending on jurisdiction. The dispute had been ongoing for years between New Zealand and Australia, claiming ownership of the name Manuka. The implication was just beyond honey. It also brings to light the importance of IP rights, including um, those related to plant variety. We now have a plant variety act protection in Nigeria. It allows farmers and those in the agricultural sectors and food sectors to protect the unique products and ensure that their quality is maintained. It highlights the potential for trade associations to set certification standards which can promote and protect their reputation in the industry. So check that out. There's a carousel for that. We're wrapping up in a few minutes. So one interesting development again that I came across was the implementation of the artist resale right, aka dropped the suit under the Art Promotion Act 2023, which will come into effect in July 2027. And the art resale right, also known as judice, is a legal concept that grants artists the right to receive a percentage of the resale price of their artwork. The right was first introduced in France in the 1920s and has been adopted in various countries throughout the world. In Korea, the implementation will take place. The implementation was done this year, but will come into effect in July of 2027, and is also considered to be a significant step to protecting the rights of artists and ensuring that they are fairly compensated. Under the new law, artists will be entitled to receive a percentage of the resale sale of their artwork each time it is sold. They will apply to all works of art, including paintings, sculptures, and photographs. The percentage the artists are entitled to will depend on the sale price of the artwork, and is considered to be like a positive development for the country's art community. Last but not the least, I think so. Yeah. So, did you know that Apple Inc. was prohibited from selling the Apple Watch Series 9 and the Watch Ultra 2 and any other new model within the United States due to their infringement of Massimo's Corp's patent on pulse oximetry technology, which uses lights to measure blood and oxygen levels. So, it turns out that sometime in October 2023, the United States International Trade Commission made this decision. This decision, however, um, up until Christmas, the Biden White House were expected to reverse that decision, but never did, as done by President Barack Obama in 2013 when Apple was accused of violating Samsung's patent. So because they did not, the White House didn't make a comment, the ban is still in effect and has also affected the stock prices of the brand. Now, what is the impact of the ban for users in other jurisdictions who want to buy or are currently using the Watch 9 series and Watch Ultra 2? First on my list is that you will definitely see a possible increase in price or a limited availability of this watch series, challenges in repairing or replacing the device. So if you own one, handle them with care. And finally, uncertainty regarding the future of blocked oxygen sensor feature, which was like the selling point for the Apple Watch series. Um, but yeah, that's a wrap from me. So, IP friends, we finally come to the end of the 2023 IP series top highlights for the year. So, cheers to 2024, cheers to making serious and good memories in 2024. Thank you for all your support, for the love. Oh my god, you guys make me feel so amazing. I really appreciate you guys for everything. I think I'm talking too much, but all I want to say is thank you for sticking with me for 2023. Looking forward to more collaborations, more money, and long life for all my AP friends and my new listeners who will bless me today by listening to my podcast. Enjoy your day. Have a fantastic and fabulous transition to 2024, and see you in a few hours in 2024.